All right, welcome back to Oberti Sullivan's podcast. Sort of like Godfather 3, just when you thought you were out, they pull you back in. We've got two bonus tips for you. Mistakes 11 and 12 on our top 10 mistakes. We just can't go without doing it. We promise to make it short. Tip number one, Mark, is, and this is a hard one, especially when you've got an employee that you just want to get rid of really bad. But employers should always remember that this is a person's life and job and how they make their money and support their family, and you should terminate with compassion.
Yeah, and even if it's, putting aside the morality of it, just from a pragmatic standpoint, I've found, I always ask plaintiffs in a deposition, why are you suing the company? And it's never, well, I decided to do an objective analysis of the facts, concluded the law was violated, so I brought my suit. Rather, it's, I was humiliated, they destroyed my reputation, they took my dignity, and a lot of times it comes down to how they were actually terminated. It leaves them feeling humiliated. And so, just executing the termination in a compassionate way can avoid a lawsuit. So, a couple basic rules. Don't fire the employee in front of others. I remember one day I went to work and I saw this lady fired. She had her little box with, the kids' statutes from Little League, and she was crying, and it was just a sad scene. And you could see this woman was humiliated, and that's asking for a lawsuit. Terminate with resolve, but compassion, short and sweet is the way to do it. And the other thing is, don't call security unless there's certain times naturally where you do. That is a good thing to do. But if it's a run-of-the-mill situation, there's no hint that this is going to be necessary. If you do have security, have them undercover, kind of on the outside, not right there, uniform, because then the person is really going to be mad and think that you're calling them a homicidal maniac or something, and that really gets them fired up, and they go to a lawyer.
So the next question, Mark, and I know companies go back and forth on this, and it's usually a big topic of conversation with their legal counsel is, look, what do we tell the employee? Do we tell the employee, really why we're firing him or her? Or do we just sort of say, you're fired, it's an at-will state, pack your bags, get out?
I mean, there's some rare circumstances where because things haven't maybe been set up the way they should have been document-wise and that sort of thing, but the company's really set on letting them go, that, okay, maybe you don't give them details. But as a run-of-the-mill situation, I like to have everything lined up, and I like to give the person something in writing that's succinct, kind of like an Exhibit A in front of the jury. This is why we're terminating you. And it's tied to your policy, and it shows due process, and it shows fairness, and it shows a compelling reason for termination. And you give it to the person, because I find when you don't do that, especially like this Miller versus Raytheon case, where you had a 30-year employee at Raytheon who alleges that he was put through the ringer, and then when asked why he was treated in this Kafkaesque-like way after 3 decades of loyal service, they said, we're not going to give you a reason, and we don't have to give you a reason under the law, so hit the road, buddy. Well, maybe they're right legally, but when you get in front of a jury, you see a $17 million verdict.
Well, Mark, I tend to agree with you, but there is something for companies to think about, and I know this is going to sound crazy to some of you, but make sure that the reason, if you're going to give the employee the reason, is the right one. Because if you don't give them the right reason, if it's not the real reason why you're terminating them, and that employee later on sues for discrimination or retaliation in most cases, and can establish that the reason was simply false, they make it to a jury on a discrimination case, barring any other evidence.
Well, that's a great point, and that ties with our one of our prior tips in one of these podcasts is you got to do your due diligence in front, and that Exhibit A, that document you give the person, has got to be rock solid. And if it's not, then you're better off not doing it at all. I agree with that.
Right. All right. So that takes us to bonus tip number 2, which is, what do you do after an employee leaves? I think that this is a concern more by employees than it is of employers. Most employers today understand that they simply verify dates of employment, and there's a reason for that. Not that they really even could successfully be sued for defamation, but just to avoid even any defamation claim, employers typically don't want to get into that.
Yeah, that's something to stay away from. Plaintiffs' lawyers love to say, not only did you fire the person, but then your appetite for destruction still not satisfied. You went and badmouthed this person around town so they couldn't get a job anywhere else. And a couple things is HR knows that they don't do that, but your managers need to know that. And another thing they really need to know is be careful of LinkedIn and social media. We've seen a couple cases where after the person was terminated, they reached back out to some mid-level manager who maybe they had a relationship with and asked for a recommendation on LinkedIn, and the manager gave it to them. Then they bring the suit and they use their Exhibit A, the LinkedIn recommendation, which of course usually contradicts what the company said as the basis for termination. So your managers need to know, hey, all these comments that are going to be made, even if they're not at the job itself, they could be tied back to the company. So loose lips sink ships, stay quiet.
Well, and it's not just that, but I could imagine where a manager gives a recommendation to an ex-employee, but then another employee didn't get the recommendation. And that there might be someone privy to both, and that can make the inference, oh, the failure to give me a recommendation is somehow being negative on my performance. And even though you really want to help your friends out or people that you work with, sometimes, just like Mark said, your best policy is to keep quiet.
Definitely. And then, of course, the last thing here, people ask, is it legal they tape recorded me without my knowledge? Well, in Texas, they have a bizarre rule called the one-party consent rule, meaning that so long as one party to the tape-recorded conversation consents to it, it's legal, which, of course, is going to be the employee. And, a lot of times those tape recordings actually blow up in the employee's face, but every now and then you have an employee who catches some direct evidence on tape. And so you want to remember anything you're saying about or to this employee and during these sensitive time periods, that might be on a tape recording, and you need to make sure that you're going to be proud and comfortable with whatever that tape recording says.
All right, that concludes our bonus tips, and we thank you for watching.